Hey folks, Greg Siskind here. I'm back after a couple weeks being out, enjoying the summer. Sorry. I'm joined by Adam Cohen, my law partner of many years, and Adam is here for a very specific subject tonight. Even though Adam comes on for other things, he's not just totally typecast, but he is our resident academic immigration expert, and I tell people that, and they say, "Well, what does that mean?" It means Adam is he's the expert on all things university, and but it's beyond that. Also, like academic medical centers,
Research and
universities,
students. Yeah.
yeah, anything having to do with like F's and J's. He's your guy. Um, Although, and we're going to talk about this horrible new rule that came out that we have been dreading for a while. Is it all right to call it horrible? Is there anything good about it?
One thing I can think of, literally one
We'll
thing.
get to that. Save your one thing.
Okay, save it for the end, maybe. Yeah.
Yeah. So we're gonna talk about what this thing does, how it's basically going to create chaos in the student immigration system. What the how this thing actually works. We've got an hour to get to talk about this tonight. We will take questions, but please stick to the subject tonight. We're not going to take questions on a million random other things because we'll be back. I know there was this very big. We debated tonight whether we were going to divide tonight between duration of status stuff and the public charge rule, both of which came out in the last couple of days, both of which have a phase-in period. So we have time to get to to talk about the public charge rule. We'll do that on a hopefully when I'm on vacation, so that I don't have to be the one who covers it. But we're going to we're going to talk about this, Adam. So this is many years in the making, sort of. I mean, it was many. Meaning this was a proposal from the first Trump administration that was kind of a holdover that got bounced and was a holdover. So why don't you kind of tell us in a minute what the thing does, and then give us a little history, and then we're going to start taking a deeper dive.
Yeah, and I think it's good to just kind of back up and to realize that this is changing like decades of practice, right? There have been some times, there were times in the past where F1 status, J1 status were limited to a date certain, but those were decades ago, right? So for most of us practicing or in the international education space, we've really, and certainly any current students and exchange visitors, they've only known this duration of status type of system, right? This is where you come into the US or you change your status to F or J, and you have your I-94 that you receive, your ability to remain, says duration of status at the end. That's the expiration date, right? And what does that mean? It's tied to you making normal progress, to your course of study or to your exchange visitor program, right? It's tied to your I-20 form for F1 students or tied to your DS 2019 for J1 students, right? And it is in recognition that educational paths, research objectives, these are not always linear. And there's a lot of need for people to have additional time to complete programs, to transfer institutions, to reduce course load, to apply for OPT, to move on to other courses of study, and things of that sort as well. Oh, you got that's the old edition, Greg.
Well,
we're up to
title is insane.
We're up to number 5, and very, very soon I'm going to have to
I'll
already start writing number 6 because of this whole rule. So anyway, so that's what we've always understood, and we've always understood that the accrual of unlawful presence and getting into all of these 3 and 10-year bars to return to the U.S. were based on when an immigration officer or an immigration judge would find that there was actually a formal violation. But that's all changing now. The students and exchange visitors are going to be put into a very similar situation to all of the other non-immigrants like H-1Bs, even though their circumstances are very different, right? And I think it's very interesting where, maybe interesting is the word, where the government is talking about how, well, this is just aligning, students and exchange visitors to everyone else, really missing the point of, again, like I was saying, there's a lot of things that require flexibility in immigration. There's a lot of decisions that are in the purview and the domain of academia, but there's also this SEVA system, if anyone's heard of this. Since 9/11,
Student Exchange Visitor Information System.
Exactly. And this is the system that was put into place in the aftermath of 9/11, making students and exchange visitors the most monitored, tracked immigration, non-immigrant categories within the entirety of our immigration system. Every move that they make, every job they take related to their OPT, to their CPT training, their transfers, reductions in course load, all of these things are heavily tracked and heavily monitored. And so a lot of what we're seeing here is very duplicative. There's been no carve outs made to any industries, despite very compelling arguments that there should be. Yeah, I mean, I could kind of wax on a lot about it, but I mean, there were a lot of, if we think about it in the lens of like least restrictive means, like there were a lot of other things that could have been put in place, increased CVIS analytics and data that's tracked by the government, focused investigations. It really didn't need to be this whole system that completely upends things and puts a lot of pressure on universities and international student and scholar offices, creates confusion for students and exchange visitors. So anyway, that's just kind of my broad thoughts on that, but we can also get into the details and see how we're really going to tackle this as well.
Well, and we have after we take this thing off, we have that fancy chart you made. Should I put that up?
Not too fancy, but no, certainly you can. Okay. Not too fancy, but I think helpful in a way. Yeah. So I mean, I'll also just say that I think, before we kind of get into that, the rationale for the government wanting to end duration of status, they're really focusing, especially we saw this in the final rule where they really started picking out these exact examples, of F1 and J1s who did bad things and violated status and national security concerns and risks. But I think it's important for everyone, I think I'm probably preaching to the choir for those who are watching this, right? But this is a very, very, very small fraction of students and exchange visitors who are
and I visa holders. We don't give
and I visas. That's true. That's
all
true.
The journalists in America who basically have never caused any problems to anybody are now, except for asking hard questions.
Yeah.
Sometimes.
But I think it's important to understand, and they clarified this in the final rule, and I think they did this in response to comments, but they're basically bifurcating the system, right? Their response to me would be, this isn't duplicative. DSOs and ROs have their job to address academic and programmatic considerations, and we have our job to assess status, abuse of the system, working without authorization, and things of that sort. So I think it's important for everyone to understand, that's their point of view, where they're coming from, which is interesting because they actually are doing curricular and programmatic restrictions, but that's another part that we can get into. But that's basically what it is. I don't know if you have any questions that you wanted to throw out about that, Greg, but we can also just, talk about what the final rule actually does.
Yes, let's get into the meat of it. So first of all, when does this take effect? Because I said we had a little time, but it's not a ton of time. So it's coming up soon. When do we need to start worrying about this?
Yeah, I mean, worrying about it now, but it takes effect on September 15th. So it's 60 days from when it was the final rule was published. So September 15th is when it takes effect. Now, not everyone will feel that impact right away because there are certain transition rules. And, it's going to be the case, in all likelihood that, I-20s and DS 2019s, they'll be extended if they can be, and people will still have until the program end date on their current, that I-20 and that DS 2019 that they hold on September 15th.
Right. Most students, unless schools start super late, but most people will have their I-20s for the fall semester that are not going to be affected by this. So, am I wrong about that?
No, that's absolutely correct. They should already have that, and so they have to that program end date plus their grace period, which in the transition rule, it's still 60 days for F1s while they're here. And 30 days for the J1s, which it will continue to be.
Is that changing?
So it's going to change for the F1 grace period. Will change from 60 to 30 days. And
so
that's
F's and J's will be the same.
Yes, that's right. And we're going to start to feel the impact of that when students have to extend their status or when they travel internationally after September 15th. And they come back because then they're going to
start. I just put this comment up because it's a fair comment that some schools have different schedules than
that's a great point. Thank you, Kara. Kara always has wonderful insights, by the way. But yeah, quarter schools. I mean, we're going to see probably ESL programs, short-term scholars, J1 short-term scholars. I'm thinking of
I should know. I went to a quarter school. I went to University of Chicago was on quarters. So I hated that. Every 10 weeks you were studying for an exam. Gotta love it. All right. So Adam, so this will for some people, as Kara mentioned, are going to be affected right away. They're on a late starting schedule. Some will be. Some will have a little bit more time. Let's talk about some. Well, first of all, also, is this affecting anything? I mean, the big thing is the changing roles. One big thing is from things that were responsibility of DSO. DSOs are now going to be handled by USCIS officials. I guess I'm making determinations on extensions.
Yeah. So it's what I'll stress is that it's not changing anything in particular about the duties that the DSO has, the designated school official for F1s, the responsible officer or alternate responsible officer, right? For J1s, it's not changing their role in that sense. It's just kind of layering over top of that this additional process of this extension, right? So you want to extend, you still need an I-20 from your school for that extension or recommendation for your CPT, for your OPT, right? And then you have that extension afterward. And you may not necessarily need one, if you're getting CPT, right? That's already part of the course of study. So you may already have a program. You may not necessarily need an extension, is what I mean to say, related to that. So it's really, I think, kind of the best way to talk it through is to just to look at this chart. I think is kind of where we can start, right? Is the effective date now, we can fill that in, right? That's September 15th. And so we're going to have those students who are present, students and exchange visitors, they're going to have until the program end date on that current I-20 and that DS 2019. In fact, we'll get to the grace period. The shorter of that, the program end date, or 4 years, that's where they're blocking them off, right? Because some people may have 5-year programs or something like that. It's going to be further curtailed by maximums for ESL, and of course, as we know, different J1 programs have their own maximums as well. Most of them are beyond, or many of them are beyond 4 years, but some of them are not. And so those are not being changed, right? They're not changing those categorical limits. So that may be a further limitation on how long you get. And then you get that additional.
So I'm just curious, what about so 4 years is the maximum that, is that also for like J1s who are in long training programs and that kind of, that kind of situation?
Yes.
What about
that? And they lobbied hard for it, Greg, too, especially in the medical community. And basically they've kept everybody the same with this just kind of broad brush rule, apart from the curricular restrictions, which we can talk about. J1 clinical trainees will still need, at least probably one extension, just depending, I guess, on how the DS 2019 is structured. But I think they're also going to have some functionality in the SEVA system that is, even if you get a 1-year DS 2019, that you'll be able to enter in a certain place in the DS 2019 the full length of the program. So I think that's going to be helpful.
All right. So joint degree programs that are longer, that's the same deal.
Yes.
Because 4 years is normal. I mean, that might be like the normal, but there are programs that are longer than that.
There are lots of programs that are longer, and then we also have to keep in mind, right, OPT filings, and STEM OPT filings, which by the way, that is, if we look at the third part in that chart, this is one of the transition rules that we have that's actually giving a bit of a nod to those who are filing OPT and STEM OPT, that if they're filing in the next 6 months after the rule takes effect, right, so maybe up until like March 17th, 18th of next year, that they can just file for their OPT, but they don't have to file for an extension. But after that, they will, right? Like after those who are applying for OPT after September 15th, 26 will have to file both the EAD and the extension as well. So everyone keep that in mind. And there's also a transition rule that is related to the J1, where you will be able to work beyond 240 days if you are filing your extension for your J1 within the first 6 months. So kind of that same period, but we can get more to the 240-day work extension.
All right. So we're going to have a lot of these extension filings, at least a lot more than we have now. And, is there a discussion about how USCIS is actually going to take on yet another task that they don't currently have to do? How do we think that USCIS is actually going to have the staffing and processing capacity to handle this? Is there any indication, sort of like what the backstop is when they get these applications and just sit on them indefinitely?
Greg, you'll be happy to know that they're extremely confident that they'll be able to process this. So basically they say that, they believe that they're going to have time for this. They believe that, I'm kind of looking at some of the comments that they had in the preamble. They don't think that this is going to materialize the peak volume until 4 years after the effective date. And I think that, they're looking at the normal trajectory of 4 years. But, obviously, as Kara was saying about quarter schools, there's ESL, there's STEM, and not everybody's a freshman in college, right? There's going to be a lot of people who are already going to be in their junior and senior year. They're already going to be needing to, to transition, maybe move into a higher level of degree or then into their OPT and STEM OPT. So I think the volume is going to hit a lot sooner than they believe it is. And by the way, they also estimate that by year 10, when they believe it's going to be the most stable sort of regular cadence of these filings, that they believe it's going to be 390,000 F extensions and 31,000 J extensions by that time. They believe that's what it's going to ramp up to be. Now,
we don't. Can you? You can premium process.
No.
I didn't think so. You can premium process to get into F or J status with an I-539, but not to extend.
That's right. Yeah, they are making no statements about, they said they're going to look into it, then consider it. Maybe they'll have some that will be able to apply for premium processing, but they just say to monitor their website on that. You can, as you mentioned, you can change status and premium process that.
Well, that doesn't help you here.
But that's going to be interesting when you have to file for extensions and you have to file for your OPT, and you can premium process one of them, but you can't the other.
What? All right. So for this massive volume, there. What are you going to tell people when when we start hitting, expiration dates and that sort of thing? Is there any kind of automatic extensions or anything like that while it's pending?
Yeah. So I guess I'll say a few things about that, Greg. So the first thing is the timely filing of an extension, right? So let's talk this through in the F1 context. So you'll have it till the program end date, right? As we said, and then there's a grace period as well. Now, you want to file this extension before the grace period starts, right? You want to file it before the program end date, because that is what's going to provide this 240-day work authorization extension of CPT, on-campus work authorization, severe economic hardship, special student relief, like these kinds of benefits. This extension is only for those who filed before the program end date. I'm going to tell people, and
right, so let me just clarify on this, because I've got the expert here. You're still in valid student status, but you need an extension, and you file for the extension before it's over and before you're using it, and before your grace period is started. What's your situation after you filed that, after the expiration, but you filed it on time? What can you and can't you do after that extension is filed?
Okay, so you are in a period of authorized stay. Okay, after that expiration, you can continue to engage in your studies, right? And I think they even allude to like unpaid training and things of that sort.
Mm-hmm.
What is curtailed is going to be the work authorization, which is only going to run to 240 days, right? And then you'd have to stop after that. But you could continue to going to school and continue to be in a period of authorized.
The work authorization, you said, that can be premium processed or no?
Well, there we're talking about something different there. For that work authorization that can be premium processed, I'm just specifically referring to OPT and STEM OPT applications.
Got
so
it. I just want to people to be sort of have a decent understanding of what their situation is during this period. So you can study and you can work for 240 days as long as you filed everything in a timely manner.
Yes, exactly. Which is before the program end date. And I think, I will say with the J1, I think it's a little different though, because it says that as long as J1s submit an extension of stay prior to the expiration of their I-94, which includes the 30-day grace period, their extension request will be considered timely filed and they'll be able to continue their J1 authorized activities. So I think that's maybe something that we may need some additional clarification for, but I feel like they are treating the Fs and Js a little bit differently there. And my big, one big takeaway from the comments that I would mention to everyone to be aware of is they are not saying how early you have to, like how early you can file, right? They're not giving a limit there. So they're recommending 180 days before the program end date, but you may even be able to file earlier. It's just, I've talked to different institutions about this, and there are procedures, right, for the issuance of an I-20 or a DS 2019. It may not be as realistic to file, vastly earlier, but there's no limitation that is being imposed. So the earlier, the better. But when it comes to OPT, right, there are still regulatory limits there, which is kind of a weird juxtaposition.
Yeah, I posted an interesting question that sometimes we forget about on-campus work. But what's an assistantships? Is that work the
Yeah,
same way, or is that different?
that's going to be your on-campus employment, grad assistantships. These are all oftentimes are considered the on-campus work, which is going to be the same thing of this 240-day extension of that work authorization, as long as you file the extension before the program end date. So it's also going to include, I know, some universities, student athletes are doing NIL, name, image, and likeness work, maybe some promotional work on campus. So that's also something to consider.
Yeah, and we have this question as well for medical residents. Let's say you're a resident, you're getting one of these forms, you're getting a DS 2019 every year, I guess. And what are you? You file for the extension. I mean, I guess it's essentially work. It is work. You're getting paid, but what is there? What happens on? Let's say you're pro. It's you file plenty of. You file sometime before June 30th. July 1st rolls around. Can you show up for rounds? I mean, what can you do?
So the 240-day extension, and I'm very glad that to get this question. The 240-day extension does also apply to medical residents. So there is some risk of disruption there. But again, applying early is going to be very important. Now, you said and are correct about the yearly, DS 2019s for J1s. I want to see what the CVIS functionality ends up looking like, because again, what I was saying before, I think that there's going to be a place in the box. I think it's the box where the category is listed, where one can also note the full dates of the J1 program, even if it goes beyond that program end date, to the left of that in the DS 2019. So it may not need to be every year extensions, but it's still going to be limited to the 4 years at least, right? Which is going to require, for those who are doing any type of fellowship work, right, they're going to move beyond, probably into that need for an extension. One other thing I want to mention to those doctors who are going to be transitioning, okay, from J1 to H1B. This is going to be an important thing too. So a lot of we know J1 waivers take some time. They take several months because they have to go through different agencies. And, sometimes a doctor doesn't get their first choice on their waiver, or sometimes they just are able to work out the particulars and they get the job later on. So they're kind of a late cycle type of J1 waiver. And they make use of board exam extensions because a lot of them have their boards after their training ends. And so they get a new DS 2019 from ECFMG and their program sponsor, and they're able to get that board exam extension. But now this is going to extend, right? It's going to go beyond that end date of the program. So it's going to, in all likelihood, it would require an extension for that, right? So we have to keep in mind then the processing and the dynamic of that that's now going to be put into place, making it a little bit more cumbersome than it was previously.
Okay. We have a question regarding transfers for J1s, but also maybe you can talk about transfers for both F1s and J1s and kind of what is and is not changing with respect to that process here.
Yeah, so transfers are going to likely, extend. They're likely going to extend the program end date. So they're likely going to require extensions, and a lot of times, they're being done to move to a different degree as well. But what I would note specific to transfers, two things actually. One of them is that there are curricular restrictions. There are restrictions on changes of transfers or changes of educational objective, including your major, within the first academic year for undergrad. Okay. And so that's going to be there. There is an extenuating circumstances exception, but we don't know what that's going to look like. So that could end up being, just sort of a difficult thing for young students who need to transfer. A lot of student athletes also transfer, some of them during that first year. And so that's going to be a tricky thing. And then there's the graduate level. You can't change any educational objectives. And there is an exception for transfers, but extenuating circumstances have to be shown there as well. I'll note one other thing, though, that is important that they are changing that I think is helpful. Campus reassignment. So schools, when they apply to become SCVP certified or renew that, they're doing it under something called an I-17. And there are university systems that are all under, where all of the campuses or many of the campuses are under the same I-17. Those are no longer, they have been called transfers if you go from one campus to another, but they're not going to be called that anymore. If they're under that same I-17, they're going to be called campus reassignments. And those are not going to be prohibited under these curricular restrictions. So some will be okay based on that.
Got it. So Adam, like in terms of the specific evidence, what specific evidence are schools and program sponsors going to have to provide now that their role is changing in USCIS and not just the school is deciding on extensions? Like, what is that going to look like?
Well, it's primarily going to be the student and exchange visitor that's going to be, providing evidence. But I think the bottom line is that this whole system is created to be a vetting opportunity for the government, right? So they're able to have these different checkpoints along the way. That smooth ride down the highway, there's enforcement at different checkpoints along the way, and they're going to ask questions, right? So there's going to be, biometrics, probably, yes, they're going to be doing biometrics, biometric appointments, looking at social media. They're going to be scrutinizing maintenance of status and progression in the course of study. They mentioned that, maybe if there are questions about this, why somebody needed extra time, maybe letters from academic departments or academic deans would suffice. I don't imagine that they're going to be as concerned in, when we talk about like progression to a higher level degree. It's really going to be more where there's been some academic issues or problems. Maybe, they're looking at consistent patterns of academic, failures or probation and, things of that sort that they're going to look at as mostly the problem on the academic side. So that may be where the resources are coming from the university to kind of help supply a letter or something like that. They're going to be looking at things like intent, right? So those who have, green cards, those who have maybe are considering
big question to distract you.
No, that's I'll get to that. That's a great question, Darren. I'll get to that in a moment. But assessing green card intent, like how far are you in the green card process? That could be something that would be looked at because some students do apply for green cards. Financial resources, which is really always a bit of a concern. Can you pay for your living expenses and your tuition? And yeah, it's really it's their opportunity to have a discretionary analysis. So anything else, Greg? So it could be other things
Sure.
you might be looking under the hood. That's sort of the bottom line. What was that other question?
Let me throw this question up again.
Sure.
So this is about timing and what I think
Yes.
it's a fair question.
Yeah, Darren, I really appreciate this question because it's absolutely true that these are somewhat incompatible timelines, right? Because the extensions, you can't premium process them. You can file them. You have a whole upper period considering what's actually realistic for the institution, to issue the I-20, right? But you have all that time, but you're still limited by the 90 days to, well, we say 60 days after the program end date. Ultimately, I mean, that's how it'll be at first, but ultimately it will change to 30 days after program end date. I would imagine because the grace period's changing. So I'd have to look at that regulation again. But so I'm thinking of a scenario, right, where you file this extension as early as possible, right, and you have that I-20 that is issued, by the university at that point, and then 90 days before you file for the OPT. Now, you can't use that I-20 that you used for the extension, right, because you have to receive that. It has to be a filing within, I believe it's 30 days, and then it's 60 days for STEM OPT, I believe, or I have that reversed. Within, when the DSO enters the recommendation for OPT in the SEVA system, right? So I guess my DSO colleagues who are listening to this, I suppose you have to reissue that I-20, re-enter that recommendation into SEVIS and reprint the thank you. That's charter, I think. Yeah. So initial OPTs, 30 days. I think it's 60 days for the STEM recommendation, right? So DSOs, do you need to re-enter that recommendation in SEVIS and print out a new I-20 then for the student to include with their OPT filing? I think that's Kara's saying something here. We might want to highlight this one. Kara's response there too. Yeah, have to be a separate recommendation in SEVIS, and they'd have to file within 30 days. So it's another thing, right? We're kind of pointing this out, right? It's another thing where it's hard enough for all of us and my international education colleagues, to remember all this. It's asking the students to do a lot more as well.
Well, let me, on a related subject, I feel I can more in my own, more in my element, talking about litigation in Congress. But this is about the Congressional Review Act and whether it could potentially be blocked. So first of all, that assumes that you have basically, if a rule is, if before a new Congress comes in, if anything that was, I believe, done, I have to look back at the dates, but I believe anything that's done within 180 days of a new, before a new Congress comes in, Congress by a majority vote can effectively undo a regulation. And there was some thoughts that might happen for some of the late Biden regulations, as well as late Obama regulations, and Congress didn't get to them, which is good. But the challenge is it's legislation, so the president would still have to sign it,
right?
And, I'm pretty sure that he's not going to sign. He would veto that, and then you have to basically override a veto. So I don't think the Congressional Review Act is mainly helpful when there's like a sweep, when and Trump could have and Trump and the Republicans could have done some things with the Congressional Review Act last year, and we were kind of like, fingers crossed that the whole time we're like, hope they don't notice that, but they didn't get to that. So I don't think you should plan on Congress saving the day here, at least not this Congress, coming Congress, even if the Democrats take charge in both houses. I do think there might be better prospects for litigation, only because there's always better prospects for litigation than getting Congress to do anything. The problem is there's a very big difference between the way the administration went about getting this in place this time versus what they did the last time, where they tried to do it by policy memo. It didn't. It didn't happen. They have been, unfortunately, learned some lessons from the first term where they just would, and they haven't learned all the lessons, but one of the lessons is go through rulemaking and you have a much better chance of something surviving. So we're not going to we're not we don't have that argument now that they should have gone through rulemaking, because they did go through rulemaking. Now, did they consider any of the comments? Probably no. Did they follow? There's a million different parts of rulemaking, on things like did they, everything from the environmental impacts to studying the costs to like a whole bunch of things that they have to follow. Paperwork Reduction Act. There's like a million of those things, and there are administrative law experts who love basically digging in and finding things that they didn't do. But assuming that's the case, sort of the biggest thing there is one big change that's great from a immigration litigation perspective, and you can thank our conservative Supreme Court for that, which is a case called Loper Bright, and Loper Bright overruled a case called Chevron, which had been the law of basically the precedent case for 50 years or so. And Chevron basically said agencies get a lot of discretion to figure out what Congress was talking about, and they get leeway. And he basically puts it puts a heavy burden on trying to challenge a regulation. And that got flipped because there was an environmental law case, and in the environmental law community, most of the time, it's the polluters that are interested in trying to overturn these rules. So they were super happy that Loper Bright came along and said, basically, you have to show that this is explicitly the intention of Congress when they pass a piece of legislation, that this is what they meant to do, and that the regulations that are out are entirely consistent with the scheme that Congress laid out. That is very helpful in certain immigration cases. So, like one example, our friend Brian Green, who is a great immigration lawyer in Colorado. Some of you that are listening may be involved with filing EB-1A cases. And there's this case from years ago called Kazarian. And basically, they created this second pass at extraordinary ability cases where you can meet the evidence categories, and then they can still say in the end, nope, I'm not buying it. I don't think you're really that great. And there's nothing in the statute that says that they can do that. And they convinced the Ninth Circuit that this was a perfectly reasonable thing for them to do. Brian said, find it for me in the statute. There's nothing like, and a judge in Nebraska, which happens to be the district court that oversees the jurisdiction of the Nebraska Service Center. This judge said, there's nothing in here, and your client, they can't do that to your client. So he won that case, and there will be more litigation challenging that. But that's an example of like, I think it might be harder here, just because if anything, duration of status never actually had any underpinnings in the Immigration Nationality Act. It was like never discussed anywhere in there, was it? No. It was all a creature of regulation, correct?
Yeah.
Yeah, that's what I think will make it harder to challenge the idea of getting rid of it. Now, did they do it are they following the way they've done it and got rid of it? I mean, is it consistent with the way that the rest of the Immigration Nationality Act works regarding extensions and those kinds of things? If it is, then it's going to be hard to challenge. If you can show that the way that the way that they're doing it under this regulation, if it's inconsistent with anything in the Immigration Nationality Act, and that's what a lot of lawyers are going to be pouring through, is then you might have a challenge. But it's definitely going to be harder to challenge it because they went through rulemaking. So unfortunately, you're going to there's already strategizing going on amongst a lot of people about how to undo a lot of these things in the next administration. And this is, we're stuck with this probably for a while, even with litigation. But it may be that the next administration decides that they can just basically revert back to the old way. So anyway, Adam, I don't know if we have we can talk. I can ask you more questions, or if we have questions for people that are here, I'm happy to post those as well.
Yeah, I mean, it may be helpful also to flag Joseph Elias had put in. Hi, Joseph. He had put in a very good point that he made. Just again, these are some of the institutional realities, right? Here he's talking about match results, right? That will make it difficult, to be able to file the extension as early as one would be able to. There's institutional considerations that limit that. So I thought that was an important comment.
Okay. What about spouses and kids, like F2s and J2s? Like, what's changing for them?
They're in the same situation as well, where they're also going to have to file extensions. Now, it is allowed, just as it is with other non-immigrants, that you can file a 539 that includes the family. They'll probably have a 539A is how they typically do it, to add different family members in there. So they do need extensions, though. So they can either do it in line with the principal, or they can do it separately. Now, one thing that often, I've seen in other categories why there would be a desire to file separately is where maybe one of the children is going to be aging out. They're going to be turning 21, earlier, and then maybe they just want to be on their own 539 to not affect the principal and the other family members who can have a longer stretch in that status. But yeah, they're gonna be part of that as well.
All right. So J1s, I mean, one of the unique things about the J's is that a lot of stuff that happens domestically happens with Department of State, which in most areas of immigration law, everything the Department of State does is involving things outside the United States and at consulates. But in the J1 context, they have a lot of the they have a lot of the functions that DHS or USCIS would be having. So how's it going to work with coordinating between these two agencies? And how's it going to work over at Department of State when you're trying to do the changes that need to be done if you're in a J1 track?
Yeah, I mean, it's going to be fairly similar, right, in the sense that ROs are still going to need to, put recommendations in, right, for program extensions or certain cases for reinstatements and things of that sort. So that's not changing, right? Just like the DSO's responsibilities aren't changing. It's the same thing with the RO's responsibilities as well. And then, the filing of the extension is going to come after that, right? With that DS 2019. So that's going to kind of march on the way that it has. And, the visa processing, is not changing either, right? If you're traveling, you don't have a valid visa, you're still going to have to acquire a visa and come back, right? So, it's a lot of people are looking at it, well, this counterpoint of, well, I don't have to file these extensions of stay, we can travel and reentry, right? But travel and reentry requires, going through acquiring a visa if one is not visa exempt, if they're not making use of automatic revalidation, if they're don't already have a valid visa. And so there's still going to be that issue. Some people we got all these travel bans, right? Travel ban countries. And then, of course, we have these CBP decisions. And CBP is going to need to be trained on all of this as well, right?
We have a question that is sort of like relates to that, which is this, is this a potential workaround
Mhm.
that you just get a new I-20 exit and re-enter on with if you have a valid F1 visa or J1 visa, well, F1 visa in the case of I-20s. Is that a viable strategy?
Yeah, well, I mean, that is something that can be done, um, apart from the extension, right? So one does, if they're not going to be present in the U.S. to finalize that extension, they don't necessarily need to do an extent. It's kind of like an either or, right? You can file an extension from within the U.S. or you can travel with that I-20 that has additional time, and then you can re-enter, right?
Right.
There's different rules that relate to, well, what if my extension of status is pending and then I travel, and we can talk a
Well,
little
so
bit.
that's a question. Let's say you have an extension of status pending,
Yeah, yeah,
and it's kind of like dragging, and you can't premium process, and I guess the
yeah.
question, and you need to travel. Would you go, to the DSO and work with them to get a new I-20 and then just present the and have a
Yeah.
visa and an I-20 and come back in with a with a new a new I-94 when you come back in that matches the new I-20?
Right. And to clarify, we're not talking about like a new initial, like a new CVIS record, or that
Right.
sort of thing.
No,
We're
we're
just
just talking like
talking,
you're at that point where
yeah,
you need to travel and we don't have an
right.
approval yet.
Yeah, and so and that's fine, right? And people will probably do that, especially if extensions really take a very long time. And so they can either come back, and they can do one of two things. So they can come back in with any remainder that they have on the prior I-20, right? Whatever's left of that period. But if the extension's long pending, that's probably gone.
Yeah.
Or they can come back with the new I-20 with the new program end date. And what's likely going to happen in that situation, what they're saying is that that's going to abandon that pending extension of stay because it is duplicative, redundant, unnecessary. Okay, so
Yeah.
it's not like a penalty. It's just that it's not necessary anymore. So you just
Yeah.
get the I-94 from CBP. And this is not
I, and
unlike
I,
what happens
yeah,
when
and I put up Kara's comment that's kind of
oh
related
yeah.
to travel because it is the appropriate caution. It's like every time you think you have a good workaround, you're reminded of
Mhm.
all these other problems that have been created, including the fact there are two problems here. One is that it's hard to find a place to give you a visa in Africa because of the so many consulates that are shutting down consular services or altogether shutting down. I'm not sure if there's altogether shutting down or just the visa services. And then there's a lot of countries that are on ban lists. So
Right.
before you decide that that's going to be your strategy, you just need to be up to date on what's available to you if you travel and you need to have a visa. Hopefully, you don't need a new visa. It won't be a problem. But if you do, you have that to add to the list of things that potential headaches with travel, which is one of the reasons why the default advice of an immigration lawyer in 2026 is don't travel. But sometimes it might make sense, like in a case here, if there's a need for it. Uh, okay.
Right. And
The
one other thing I'll just mention too, related to the travel, right? Because this is something that's going to be new to F and J. I know a lot of my DSO and RO colleagues, they're aware of this. But students and exchange visitors may not. That when they travel back, when you have a date certain I-94, right? It can be limited by your passport expiration. And so it's very important with all non-immigrant categories, that have this date certain, which is pretty much all of them at this point, very soon to be, that you have to pull that. You want to check and know what your passport expiration date is, but you need to pull that I-94. If they don't give it to you, you have to retrieve it electronically after you enter, and you need to really be very careful about reviewing that I-94 to know what that expiration date is. So that's something that's going to be the responsibility, largely on students and exchange visitors to do. There may be some CVIS functionality that helps with that, where they say what the I-94 expiration is, But we know that there's already technical issues with CVIS, and there's been for many years. And if it's going to start pulling in like ADIS, CBP entry data, and you mix that with other, USCIS claims data, it's not, the data feeds don't always work very well. And so it's just, a message, public service announcement for Fs and Js to take control of that, and just make sure they're aware of those expiration dates.
Okay. So Adam, we're in like the final minutes of for tonight. What is your sort of like your takeaway here as far as your takeaway for students first, and then for DSOs and ROs second?
Yeah, absolutely. Yeah, that's a really good question. So let's start with the students. So my big sort of charge for the students and task for them is to make sure
and the J1s, whatever they are, if they're not students,
and exchange visitors, yes, to educate yourselves. Just try to listen in on any type of webinars, and there are different resources out there. There's the International Student Resource Center. I have to give them a plug because they do some fabulous, excellent work. International Student Resource Center. And they have FAQs and position papers, President's Alliance on Higher Education. Of course, there's NAFSA, but you have to be a NAFSA member to access a lot of those. That's the Association of International Educators. Read all the communication that is coming out from your university and their messaging as well. Be aware of the program end date on your I-20 and your DS 2019, because it's going to dictate your status, right? You can add in the grace periods on top of that. Be aware of, as we were just talking about, right, the risks of international travel. Don't travel on September 16th, the day afterward. just remember, you remember, Greg, the whole, very early first Trump term, when the travel ban started, right?
Well, we had it happen with the H-1Bs last year. So the panicky weekend. All right, so that's good advice. That's good advice for
a couple other things.
Okay.
Sorry. Be aware of the 6-month OPT transition rule. Take advantage of that window. J1s, take advantage of the 6-month window for the J1s to get that full extension of the J employment activities, think about your future educational plans. We didn't really get to this very much, but there are restrictions. I'll just briefly say, we talked about the transfers, right? But there's also these, 24-month lifetime cap for English language training programs. There is a cap on, there's restrictions on lateral matriculations, bachelor to bachelors, for example, or reverse matriculation, bachelors to associates. They want to see that progression. So you want to structure accordingly and to realize that they're only counting this for programs that are being completed after September 15th of this year. Okay. Think about filing extensions early prior to the grace period, always pulling your I-94. There also was some comments about, taking advantage of dual degree programs, or double majors, like having planning early to have those together, those types of programs. So anyway, sorry, that's the student side. So now the operational considerations. Honestly, I'm preaching to the choir, because I know, my DSO and RO colleagues and university colleagues are already on this. But a lot of them have already been meeting with all stakeholders, at their institutions, bringing in general counsel, the leaderships, the deans, admissions, HR, the academic departments, just getting everybody aware, probably athletics as well, given the transfer restrictions on the first year. They are messaging or working on messaging that are going to be sent out to students. They'll be doing, have resources on the website. They'll be doing you know, probably seminars and things of that sort, and messaging around how students can take advantage of, that 6-month transition period for OPT and international travel. I think a lot, Greg, of universities are kind of trying to figure out what their role is going to be in this 539 process, right? Because it belongs to the applicant. It's not a university filing, right? So we get into issues of, any type of liability risks associated with this, and veering into the space of really controlling that 539 process. I don't think that that's going to be very common, but it's probably going to be more a guidance and resource thing. And the students are going to just have to decide whether they want to work with immigration counsel to help them with those filings, or maybe if there are certain complications, where they need support or need help early and initially in the filing. So it's going to be a lot of things.
Sounds like the international offices are going to have a lot more fires to put out, which is not that you don't, not that those folks don't have anything to do already. That
right.
This is just it's a new level of headache for that for folks in that field, which I admire you guys. Okay, well, Adam, I know that going through this, I feel like an hour probably didn't do it justice, but hopefully people got some good information. I guess that you can also, I think, Adam, you can post, if you want to post some links in the firm's Facebook or YouTube pages. I know a lot of people that were watching tonight were watching on YouTube. You had some links of some resources that might be helpful. So
yes, SEVP, Student Exchange Visitor Program, is going to have some resources like FAQs and a webinar coming. We will get those up for you all. Probably put it on our Facebook and our LinkedIn page, and I think we can get it on our YouTube page as well.
Yeah.
So,
all right. Well, thank you, everybody.
Thanks, everyone. Thank you for